Welcome to all of you who are joining us for this second session of our HR Bootcamp for Healthcare Employers series. After hearing myself drone on for 45 minutes at the last session, I brought in one of our experts so that we can have a little bit more of an interactive discussion here today. So Pete Jones is going to be joining me. For those of you who have attended Bond's webinar that we do on Tuesdays, anytime in the last 3 years, you know Pete, and you are familiar with Pete's level of expertise in this area. So Pete is going to be joining me, and I think we have a great program for you today. Next slide, Kathy. So we're going to talk about 3 different topics, all of which directly impact the healthcare industry. The first 2 of which are unique to the healthcare industry. So Pete is going to give us an overview of the rules regarding mandatory overtime, changes to the law that have happened this year in that regard. And we'll talk about some issues that we're seeing with respect to mandatory overtime. Pete's also going to talk to us about the rules regarding clinical staffing plans in New York. Where are we? What are those rules? And then I am going to talk a little bit about avoiding discrimination claims in hiring, which are incredibly common, and we'll talk about some simple ways to avoid pitfalls there. So let's get started with the content. Pete, welcome, and take it away.
Thanks, Adam, and good afternoon, everyone. It's great to spend a few minutes with you today. Adam and I were just sort of brainstorming topics, and this particular area seemed ripe to revisit a little bit, given the challenges that we all face with staffing in the healthcare area. So the first thing we wanted to touch on today was the mandatory overtime law, labor law section 167. I expect that everyone's pretty familiar with this. Originally enacted in 2009. It is the so-called, no mandatory overtime for healthcare workers. It technically would be triggered by hours beyond regularly scheduled hours, and so, your schedule, the amount of hours that an employee is scheduled is going to be a very important concept here. But I assume people are generally familiar with this as originally enacted. I would, really call your attention to some provisions that were enacted later last June in 2023 that have amended this. But before we get there, let's review just the exceptions that were available and remain available under the statute. Okay. So mandatory overtime not being permissible, being prohibited by labor law section 167, unless we've got some of these exceptions, or one of these exceptions that's applicable. Obviously, an ongoing medical procedure, the 4th bullet here, kind of speaks for itself. The 3rd bullet, an unforeseen emergency where it's necessary to provide safe patient care that could not be prudently planned for. That's the exception that we face in most low staffing situations. Over the years, the regulators have told us that, routine absences and vacations and call-offs and things of that nature are not unforeseen, that they should be things that we can plan for. I'm not sure that is the case, especially when staffing is so tight. But you have to be careful when applying this particular exception because of the narrowness with which the DOL has viewed this over the years.
Pete, if
go ahead, Adam. Sure.
Could interrupt for a second here. So on that issue, you mentioned that the regulators have given us some of their opinions on what this means over time. And have you seen that occurring when, or I should say, in what context have you seen regulators getting involved in this issue?
Well, we've seen since the passage of the statute, from time to time we get a complaint and notice from DOL that they'd be investigating. And there was no real remedy here. Nobody wanted, DOL to find that you had, failed to meet the provisions of labor law 167, but there wasn't a penalty provided in the statute. Of course, that's been changed now. But this was typically what the employer would say, that either there was an ongoing medical procedure, and those I think were, fairly easy. But it's unforeseen, and we couldn't do it, and we had to mandate that somebody work, either that they stay or that they come in early, because we've got a staffing issue. And over time, I think DOL was telling us, look, the fact that that happens from time to time is something you should be able to account for. It's not unforeseen, and that may have been the case in 2009. But I think in 2020, for instance, 2021, when we don't have enough nurses to staff, it may be foreseeable that you're going to have a problem, but it's not foreseen the extent of it, and it's certainly necessary to provide safe patient care.
Could an unforeseen emergency be something like, let's take our North Country hospitals, for example. There is a terrible snowstorm or something that would prevent staff, nurses from getting to the hospital. Would that be something that would constitute an unforeseen emergency?
Yeah, I believe so. I believe so. And I think even, let's just say the flu goes through, through the staff. That's not something, is it possible? This is the thing we probably studied in law school about, what's unforeseen versus, foreseen, but things that are going to happen are not necessarily, for purposes of this definition, foreseeable. I guess I'd put it that way. The declaration of a state of emergency was very significant during the period of COVID. And I think a lot of us had forgotten, what our underlying language was in collective bargaining agreements because of the mandatory overtime statute. But when the state of emergency is in effect, you then revert back to whether or not you've got the right to schedule mandatory overtime. And so that's a helpful provision to have, even if it's in a management rights clause, in the event that there's a future state of emergency or, healthcare crisis, either locally or statewide or on a federal basis. So in any event, those are that hasn't changed. But those are the exceptions that we would look at. I think they're more important now because we're going to have penalties, and we're also going to have notice requirements. So the mandatory overtime during an emergency also carries with it, and Adam, this is what you were just we were parsing out a little bit. But we also need to make a good faith effort to cover the overtime on a voluntary basis before we can resort to mandatory overtime. So it's both unforeseen, but it's also that you've made the good faith effort. And that would include calling, or, probably in today's day and age, more likely texting our per diems, trying to use agency nurses to the extent that we've got those folks available, and, at least enough notice to be able to schedule them, floating people, if necessary, to other units to avoid having to mandate somebody, and trying to request additional work from off-duty employees. All these things are in the category of voluntary. Yeah.
Should these good faith efforts be memorialized in some way?
That's clearly best practice. I know a number of our clients, I think, that would just take a sheet of paper and have the names on it of people that you could call or text, and it would include potentially all of these kinds of folks, and then you'd be able to document during periods where you're especially tight or the census is especially high, what your efforts were, so that you can demonstrate that if you get a complaint or an audit later on. Okay, so Kathy, if you could move to the next one here. So I mentioned this new legislation, and now we've got a reporting procedure for if you're going to utilize the exceptions. And so if an employer mandates overtime under an exception, they need to provide notice to the Department of Health, including, the things that are listed here. And so, and I think the idea was to give this statute a little bit more, for lack of a better word, Adam, that's a legal term we like to use, but I think that there was a recognition that the statute, although it was on the books, didn't have a lot of checks and balances in it. And so this is one of the things that was added. Another part of this is that there's an enforcement officer regarding complaints, and these things are jointly overseen by the Department of Health and the Department of Labor. And so now we've got a procedure in place that allows the state to look at this a little bit more carefully. And then we end up with the penalties here, okay? And these penalties are new, and they're now included in the statute. And, obviously there's financial consequences. There's also a penalty if you fail to report the mandated overtime. Now, when this came out, I was telling Adam this story earlier today, but, I went to a lunch where there's a bunch of employment lawyers present, and one of the state legislators who had been involved in this particular legislation was kind of indicating that this was an accomplishment and it would help. And I couldn't help but think, I don't think it will. People aren't mandating because they want to save money. And so, in my view, finding people to try to get them not to mandate is not going to be a helpful remedy. People are mandating because they don't have enough staff to operate safely at various points in time. So I understand the rationale for it, and I understand that without some penalties in the statute, it may have invited, certain people to be tempted to be scofflaws. But I don't think the idea that this remedy will change, how units are staffed or the staffing situation overall is really a strong notion, because the problem is there aren't enough nurses, not that people are trying to save the money and that these fines are going to influence behavior.
Pete, since these penalties have been put into place, what have we seen? Have we seen the commissioner going after clients more, or what's been the result so far?
I haven't seen a lot of this. And I'd be interested if any of the folks who are on want to put something in the chat on an anonymous basis, or whether they're aware of friends who may have seen some of these things. But I don't think we've seen a lot. I think that everyone's trying to staff as best they can, and if you get into these situations, the emergency exception probably is a reasonable notion with your employees and with your collective bargaining agents until it gets to a very acute point. And that's usually when we saw the complaints in the past. It's not the first time that ever happened. It's when it starts to happen over and over, and then somebody gets frustrated and then they file a complaint.
Yeah, I was just going to say, have we historically seen the complaints coming from individuals or from unions or from a mix?
Yeah, I think mostly from individuals. I mean, ultimately, it's typically not, you don't know who filed the complaint or who made the complaint. It's entirely possible that a union representative would make a complaint on behalf of employees, and that's how the issue gets there. But for the most part, I think these were individual employees who didn't like what they perceived to be interruptions in their life, being held over, or things of that nature that happened, on a kind of a repeated basis. So, all right. So, lastly here, I would just say on this particular topic, you're supposed to display the poster. To me, this is not the sort of poster that we've usually seen. It is available on the DOL website, but it's not it doesn't really feel like a poster. I don't know whether there's going to be a different poster or a more, what I would call a more poster-like poster down the road. But for right now, we do have this. So so we'll that's where we're that's our poster for now, at least. So a couple of thoughts here, and Adam, I invite you to unmute and join me here as we just walk through it. But Kathy, if we can go to the next slide. Obviously you're going to have the potential for complaints to the state, and now those have a monetary component. I suspect you may have the ability to make some good arguments and possibly even negotiate penalties if you get into a tough situation. And obviously, if there future states of emergency or things like that, would create an exception for you. We also could see potentially labor arbitrations. Typically most arbitration clauses involve violation of the collective bargaining agreement, not violation of the law. And in fact, I did have during COVID a union challenge alleging a violation of 167. And we said there's no violation because there's a state of emergency. So then they tried to pursue a claim under the CBA, which provided for a limited right to assign mandatory overtime. And so that claim was likewise without merit. So, but we could see things there to the extent that your contract is not clear. And even if it is clear, most contracts usually have some stated or implied reasonableness. That an excessive amount of mandatory overtime could still get you into an issue with an arbitrator. The last thing I think is that I wanted to just mention, and it'll also be pertinent when we talk about the clinical staffing plans in just a second, is if you are in a staffing, for lack of a better word, a crisis or a situation that requires you to mandate, I do think we need to think about at some point the impact on potential legal claims. And I think this goes both ways, that if you don't mandate and something bad happens, are you going to be accused of violating the standard of care? And of course, if you do mandate and have to mandate repeatedly, and something bad happens, will there be an allegation that, you're understaffed and your staff is exhausted, and the people who are mandated, if they are involved, violated the standard of care? I do think, Adam, the standard of care is going to have to be the key to the lawsuits to begin with, but these may be features that are used as factual evidence, relative to those claims.
Absolutely, Pete. Any plaintiff's attorney who represents plaintiffs in a medical malpractice claim are going to look for anything that might tend to show that the care provided was substandard. So if you have nurses who are mandated to work overtime under this emergency declaration or whatever the case may be, that's something that and a good plaintiff's attorney will attach him or herself to. It's the same. We're going to talk about staffing plans in just a minute. Staffing plans could be a potential source of headache for a defense attorney defending a med mal claim. Because if there's a staffing plan that's been submitted and the plaintiff's attorney could show that the staffing wasn't in accordance with that plan, you may have issues there as well. So certainly this is something that could impact pending lawsuits.
Okay. Let's leave this topic at that. And with that, we'll move on to the staffing plan legislation. I'm just going to briefly go over this because I'm going to assume that that folks have already been through this and have some facility with it, and then we're going to talk about where we are today and what that might mean. But just very briefly, this legislation was passed. It is contained in Public Health Law Section 2805-T. That'll tell you how many provisions there are in 2805 as well. But I think the idea here was to try to encourage staffing levels within hospitals, at the same time not mandating particular staffing levels, as some states have attempted to do, in light of the fact that the staff is just sort of simply not there. So I think the idea was, at least for phase one, have a clinical staffing plan and collect data and, try and assess how people are doing against that plan. And that could be a precursor to further pushes on the legislation, or attempts to see if maybe we don't need to go any further because the problems have been addressed. But so, and I'm just going to breeze through these things quickly again, because this is the background. But you're supposed to have a clinical staffing committee, and there's some very prescriptive provisions that talk about who's going to be on it. And it's got to include, a lot of rank and file members of the healthcare team, and also people from general hospital administration. And the idea, I think, was to get a bunch of people together to make sure that we didn't miss anything in terms of staffing and then how these committees would work. So next slide, please, Kathy. Yeah. So they then doled out the responsibilities, and these are statutorily provided, but develop and oversee the implementation of annual clinical staffing plan, and which would provide specific staffing for each patient care unit and each shift based upon the needs of the patients. And the idea was that this plan would be also part of the budgeting process. So then the information would be made available to the public. And I'm not going to go through all this, but it's very, very detailed. And if you do go onto DOH's website, and I suspect a number of you have, you'll see these plans have been filed. And they are all in a similar format. It's kind of an eye bender if you look at it, because you got all this data, I mean, a lot of people probably would not take the time to parse the data and compare and contrast, and then try and look at whether we're staffing to that level or not. But I guess frankly the data is there if anybody's inclined to try and engage in that exercise. So there was I think a real reticence here to overstep. So this was not an attempt to say, if you follow a staffing plan, you don't have to follow other rules and regulations. It's not meant to diminish other standards contained in state or federal law or in the CBA. And then it's supposed to be reviewed. It's not supposed to just be on the shelf, but reviewed periodically, so that it's kind of a living document. These plans are to be submitted annually, every July 1, and that's supposed to trigger an additional series of actions by the Department of Health. And again, this is kind of like this call and response kind of activity that's supposed to go on periodically to make sure that everything's been updated. Next slide, please, Kathy. So in fact, let's go forward a couple more here, because I want to really get into. Yeah, this one is a good one. Thank you. You do need to have in your plan a process to have a complaint process, investigate that process. And if it's not dealt with adequately after a period of time, the department itself may investigate potential violations and outstanding complaints. Now, I don't think we've seen a lot in this area yet, and maybe we won't. I think unions typically are favoring the idea that they're going to enforce their CBA provisions. And if they've got staffing grids in their CBAs, typically those have financial consequences associated with them. So, people get understaffing pay or some sort of premium pay if they work under conditions that don't meet the grid. So that may be the more fruitful avenue of complaint than going to the Department of Health on this thing. But so to this point, I don't think we're seeing a lot, but you never know.
Well, that's what I was just going to ask you, Pete. Is that what you're seeing more of, individual nurses bringing claims through their union, or going to the Department of Labor, claiming that we made a violation of our plan?
Yeah, I think that the collective bargaining agreement is probably that's clearly the more common route that we've seen. I don't know that that means that this thing might not become a source of some activity and possibly, that we'll see civil fines and things of that nature. But, to this point, I don't know that this particular scheme doesn't do a lot for the employee. A union grievance typically does, right? I mean, the union wins that grievance, there'll be money associated with that. And that's usually, that also inures to the benefit of the union. They kind of can point to the members as something they've achieved. So I think that's really where we're seeing most things right now. So to kind of sum it up, I mean, I do think that the CBA provisions are still paramount. To my knowledge, most employers have not put these staffing plans into their CBAs. They've got some pre-existing staffing provisions in their CBAs. I think we may see a push to put those into the CBAs from the unions, because then they would have the ability to grieve that, and there could be financial consequences associated with not adhering to that. So we have seen certainly arbitration activity under these provisions, and awards. Some hospitals have been subject to awards for failing to meet the staffing grids or the staffing plans that they have in place. I would note that those cases are also very fact specific. Usually there's a provision in the CBA that talks about a grid number or a staffing ratio, but there are questions about, how long you have to be below that ratio each shift to trigger it. What about breaks and, things like that, where you're going to potentially be below? What about acuity? What about the time of day? Because, obviously, overnight is typically a little less busy than the other two shifts. So there's an awful lot there. And Adam, the last point here that I had outlined, you've already touched upon, but will there be some impact? Could there be some impact if we don't staff to our clinical staffing plan on lawsuits where there's an allegation that the standard of care has not been met and harm has occurred?
All right. Well, thank you, Pete, for going through all that. If anyone has any questions about what Pete presented on, feel free to put them in the Q&A, and we will get to those if we have time today. Also, I want to note that one of you asked if we could send around the link to that poster, the Labor Law 167 poster. Kathy put that in the chat for everyone. So if you wanted to access it, it is there. All right. So now we're going to move on to discrimination claims in hiring and some best practices for how to avoid those. I will say that in my practice, from time to time, I will see an employer who gets a claim from an employee that they weren't hired because of some protected characteristic. These are difficult claims to defend against because oftentimes they're very subjective. And, an employer might say to me, oh, geez, Adam, I didn't get a good feeling about this particular applicant. So we're going to walk through some of the ways that we can guard against those claims. And I will say these claims come from a couple different sources. First of all, a lot of times the claims will come from an actual applicant, someone who applies for a job, doesn't get it, and then jumps to a conclusion about why they didn't get the job. So they will say, I didn't get the job because of my gender, my age, my race, etc. Other times you will see serial filers of complaints. And Pete, I think you probably have come across these people. They scour the internet for job advertisements. And if they find something that could potentially be objectionable under one of the various anti-discrimination laws, they'll file a claim with the EEOC or the Division of Human Rights. And it's essentially a shakedown. There is some good law on the state Division of Human Rights side that says if an individual doesn't have a bona fide interest in the position, that they're not able to recover on such a claim. But on the EEOC side, the federal investigators might look at that and encourage you as the employer to pay a little bit of money to make the claim go away. So these claims come both from actual applicants as well as these serial filers. Next slide, please. So the first thing, and it goes, this is a step you take before you even advertise for a position, is you conduct an analysis of the particular job. You look at the duties, you look at the functions and the competencies that are relevant to a particular position. You then have to, it helps to write down the objective job-related qualification standards that you're going to be utilizing for whatever advertisement you're putting together. And I say here, what are the essential functions of the position? Because when you're creating a job description, if you have a listing of essential functions, that is something that can protect you down the road should somebody make a claim that they need a reasonable accommodation. I can tell you of a specific instance, specific case that I had recently where an employee requested an accommodation. The employer said, we can't grant your accommodation because you're not able to perform the essential functions of the position with or without an accommodation. And the employer had a job description which specifically said, here are the essential functions of the position. It was incredibly helpful in defending the claim, which was dismissed. So having these objective, clear job descriptions is a good way to avoid a discrimination claim at the outset, but also down the line if you want to defend against a failure to accommodate claim as well. Next slide, please. So if we've put together a good job description for our advertisement, we've put together our job ad, but there are some application and interview issues that we should also be concerned with. So in general, information obtained and requested through the pre-employment process should be limited to what you need to determine whether the person is qualified and a good fit for the position. A couple of things to note: employers cannot make pre-offer inquiries about disability. You cannot, you should not, I should say, make inquiries regarding other protected characteristics as well, such as age, race, etc., unless there's a legitimate business need for that information. And I will tell you that courts take a very restrictive view of what a business need is. So if you're going to say, I need to have this information to evaluate whether the individual qualifies for the position, you really need to have, it's got to be information that you need to have. It's a must-have type of thing. Even if information is not prohibited, inquiries regarding protected characteristics may be used as evidence of an employer's intent to discriminate. And here's how that comes about. Job applicant gets asked one of these questions, either during an interview or on an application that gets to a protected characteristic. The individual does not get the job. The individual then files the complaint with the administrative agency or court and says, I was discriminated against, I wasn't hired because of my protected characteristic. Courts have said that individual can use the fact that he or she was asked about the protected characteristic as evidence to support their claim. So even though you might think you need the information, the individual who doesn't get the job and later sues can use the fact that you asked as evidence to support his or her claim. Next slide, please. So there are a number of questions that you should avoid in applications and or during interviews. So questions about salary history are now prohibited under New York law. Questions about citizenship, applicant's place of birth, or immigration are prohibited, although you can ask if an individual is qualified or eligible to work in the United States. You can't ask about marital status or family status or childcare status. There are laws protecting individual status as family caregiver. You can't ask questions about disabilities, like I mentioned, or medications currently taken. You also can't ask questions about genetic information, like a family's history of certain conditions. Do you have a history of mental health issues in your families? Things like that. Next slide. Questions about race, religion, ethnicity. According to the EEOC, these are questions you should avoid. Questions about age, unless it's used to verify that applicants meet age-related legal requirements. An anecdote about that: I represented an employer who had listed they were running some kind of postgraduate internship program, and in the advertisement it sought out young applicants and recent graduates, and the EEOC has taken the position that those statements are enough to create an inference of discrimination, because those would tend to discourage younger applicants or older applicants from applying for the job. So these are the ticky-tack type of things that can get employers in trouble.
Hey, Adam.
Yeah.
So it probably wouldn't be right to have a webinar or anything else these days and not say a word or two about AI. So the EEOC has also put out some guidance on the use of AI in hiring. And I think when you talk about these kinds of things and whether there could be implicit discrimination issues or things like that, there's guidance both generally on the use of artificial intelligence to do screening. That's typically where we would see it, as well as a disability guidance, a separate guidance from the EEOC on that. And I think the short answer on both of those is that, because those devices can be used for screening, the employer needs to make sure that they do not have a disparate impact on the applicant pool, that they don't disproportionately screen out people based upon their protected categories or people that would need accommodation in order to perform the essential functions of the job. So I think we just, if you're doing 3 positions a month, you may not be using AI. Maybe you're reading everything. But if you're doing an awful lot of hiring, and I know a lot of employers are with larger operations, I think these tools are available and some people are using them. So you just have to make sure that they don't have unintended consequences.
That's a great point, Pete. It's you use the tool as a sense of security, to provide a sense of security, like that I'm using this, it's objective, and therefore I can't possibly be discriminating against applicants, when in reality, they can have a disparate impact on certain groups. I put a link here in the slide to a nice publication that the New York State Bar Association puts out. It's got a chart that shows what questions you can ask, what questions you can't ask, and why. And I think it's a helpful resource if you are wondering about a specific question and whether or not it's a good idea to ask that question. This resource would be available to you. Kathy, correct me if I'm wrong, but the presentation slides are going to be available to everyone. Is that right?
Yeah, they will be. We'll send them out afterwards.
Okay, great. Next slide, please. All right, so the last part of this avoiding discrimination claims in hiring presentation deals with evaluating candidates. So you've put together the job description, you've put together the application, you are conducting your interview, and now you have to evaluate the candidate. What are some best practices for avoiding discrimination in evaluation? Well, first of all, having a uniform process is the best medicine here. You have a structured interview. You can use a standardized form. You have trained interviewees, people who understand the rules, understand what they can or what they should and should not be asking about. You have interviewers taking notes, careful notes. If you're utilizing a scoring matrix, it's utilized consistently on whatever form it is that you're using. And then you have a consistent procedure for getting from the interview process down to an offer. Is there a way that you are comparing applications, resumes, interview notes of different candidates? How is that being conducted? And just making sure that there is a uniform process in place. As with all discrimination claims, the best way to avoid a discrimination claim is to have documentation of your process, documentation of your rationale. And that's the same whether you're disciplining someone or deciding whether or not to hire someone. The more you can see on paper to understand exactly why you did what you did, the better it will be defending against a claim in the future. So I hope this was helpful. We wanted to cover some staffing issues, staffing topics that we know are relevant in the healthcare industry. I will just put out a plug for our next presentation in this series, which is going to be, I believe, January 11th. It's the second Thursday in January. We're going to cover employment discrimination claims and trends we're seeing in employment discrimination claims targeted toward the healthcare industry. So thank you so much for being with us. Feel free to fill out that survey if you want. Let us know what you like, what you didn't like, so that we can tailor these presentations to you in the future. Thanks for being with us. And Pete, thank you again for joining me. And we will see everybody soon.